Hello guys, myself Mohit and I am going to dictate you Steno Legal Matter. Please subscribe my channel if you will like it and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start. Contention raised by the counsel for the applicant is that PW1 was suffering with a serious ailment like chikungunya, and so he could not examine himself in the court on a few dates, and adjournment was sought and also granted by the court. Stop. But later on, at some stage, the adjournment was refused and evidence of PW1 was closed in the midway. Stop. This closure of his evidence is likely to cause serious prejudice to the interest of the prosecution. Stop. Another submission is that the statement of PW2 also appears to have been misplaced, and in place of it some carbon copy is said to have been kept on the record, and that also speaks about the high irregularity which has crept into the proceedings, and in that regard the statement of PW2 needs to be recorded again, but the presiding officer seized with the matter is not acting in accordance with law. Therefore, the proceedings should be transferred to any other court. Stop. Para. While rebutting the submissions placed by applicant's counsel, it was pointed out by Shri Rahul Chaturvedi, learned counsel for the opposite party number 2, that the matter has already reached at its terminating stage and the transfer application has been moved only with the object to scuttle and stall the proceedings. Stop. Moreover, if the applicant felt aggrieved by any of the orders passed by the court below, they should have been challenged before the superior court, which has not been done so far, and instead of challenging the judicial orders passed by the court below in a superior court, the applicant has jumped the gun and choose to move the transfer application, which does not appear to be a justifiable course. Stop. It was also pointed out that the accused are in jail, and any unnecessary prolongation of proceedings will seriously prejudice the rights of the accused. Stop. Para. All the contentions which have been placed by the applicant's counsel appear to be in the nature of criticism of the orders passed in judicial custody by the trial judge. Stop. If any order makes the applicant aggrieved, he should have challenged the same in the superior court, adopting proper legal recourse, but the same does not appear to have been done. Stop. A judicial officer may pass a correct order and may also pass an incorrect order. Stop. This is how, and that is why superior courts come into play, took into the correctness of the subordinate court's order, and then pass appropriate order with regard to the same. Stop. Different courts, like the courts of revision, the courts to entertain applications under section 482 CRPC, the courts to exercise powers to issue writs, etc., with separate jurisdictions, have been carved out to exercise such respective jurisdictions in the High Court. Stop. But passing of the incorrect orders, even if it is presumed that the same has been done, does not constitute a legitimate ground to transfer the trial.